Shri Rajkumar Dhoot, my colleague in Parliament and President of ASSOCHAM, Shri Anil Agarwal, a leader in his own right, my old and very dear friend, Lalit, Bhasin, Pankaj, Mohindroo, D.S. Rawat Sahab, members of the legal profession gathered here, leaders of industry, my friends in the media, ladies and gentlemen. We're discussing about competitiveness of corporate India and the legal system. And I'm very happy that the 92nd meeting of ASSOCHAM has started with a discussion on this very important subject. Competitiveness is inherent in human nature. In the context of the fact that when human beings realize that a particular resource in nature is important for their own well-being, all of them want to get at that resource. And when there is scarcity of that resource, the competitiveness increases. And that's why way back, much before capitalism dawned society, we were living in a collaborative, civilized structure where there was no competitiveness with respect to resources because everything was aplenty. And so you had the barter system. But as soon as availability of resources diminished, everybody wanted to scramble and gather the same resource for his or her well-being. And as we move along in the 21st century, this competitiveness will become even more, what should I say, competitive, because resources are few and takers are many. And that's one reason why to deal with competitiveness, we require rules and regulations to ensure that the larger public interest is served. That's one aspect I just wanted to place before you. The second aspect I wanted to place before you is the genesis of law. What is a legal system? Any system that helps two people to interact with each other on the basis of any norm is law. The acceptance of an objective manner of dealing with each other is the foundation of law. And civilized society cannot move forward unless we accept that there are certain rules on the basis of which we need to deal with each other to ensure that we live in civilized society. That requires a certain element of objectiveness. If I have an interest in A and you have an interest also in A, we need to decide between ourselves as to how to deal with A. It may be a resource, it may be any entity. Now, once we agree to do that, that becomes the foundation of our conduct. Unfortunately, in civilized society, and this is true not just of India, anywhere in the world, most of us are not given to deal objectively with these issues. Because the day we deal with them objectively, there is no problem. Everybody has a subjective point of view on the issues that we deal with. who should get what, how he should get it, in what manner he should get it. We all look at it from our point of view. We don't look at it from the larger context. And the day we start looking at it from the larger context, we'll have peace and tranquility in society. But we don't do that. And if you look at human conduct in every field, you will find that none of us look at things objectively, because you always think of our own self-interest. If it's the corporate world thinks of its interest. Nothing wrong with that. If it's the government thinks of its interest. Now, there is a catchphrase which runs through the Constitution, and it is the foundation of all human activity, and that catchphrase is public interest. Now, all of us want to serve the public interest. The corporate sector says they want to serve the public interest because the more they earn, the more they will invest, the more they will invest, the more they will generate the economy, and more jobs will be created, and therefore they'll serve the larger public interest. And therefore allow us to do what we want to do. Don't please hamper us and hamper our activity with unnecessary rules and regulations. That's their definition of public interest, which is fine. The government's definition of public interest is you're making too much money. You know, you also must serve the larger interests of society. Why do you want a 30% profit? You're making a windfall profit in this sector. You're not giving anything to society. We need to regulate you. We need to make sure that you actually go along the track which is consistent with our concept of public interest. And the judiciary tells us, no, but we are the sentinels of public interest. We are the sole repositories of public interest. Why? Because we interpret the law. We are the final word under the Constitution. Our dictum prevails because we know what is best for you. And so we will decide for you how to go about doing things, because we believe that public interest will be served much better in this manner. We don't believe in your decision-making processes because we think that it will not serve the larger public interest. We need to deal with corporate India in such a way that corporate India is a responsible entity in our vision of public interest. So what you have in the 21st century, and in India in particular, competing concepts of public interest. Now, these competing concepts of public interest can only be resolved if we objectively agree on what our aim is. What is our aim? Why do we have governments? Why do we have the corporate sector? Our aim ultimately is to improve our lives. In very simple terms, we would wish to improve our own lives, and in turn, the lives of the common man. And if we look at our own activity in the context of this vision and agree that that is our aim, I think a lot of these problems will be resolved. When a judge decides a particular matter and he looks at public interest in the context of his own perception of public interest, he must make sure that that public interest fits into this larger vision. If he says, I will cancel all the licenses, not realizing that this would lead to a large public debt, which in turn will strain the banking system, which in turn will bring about a downturn to such an extent that it will bring a prosperous industry into steep decline. An industry which was contributing substantively to the GDP of our country, to a situation which is now confronted with a debt of over 2 lakh crores. Remember, behind the cold print of the law is the soul of a vision. You can decide on the cold print of the law, but you cannot possibly realize the consequences of that and the impact of that decision in cold print on the lives of ordinary people. Which is why under the Constitution we have this separation of powers, because it is not the domain of the judiciary to fully understand the vision of a government which seeks to attain a particular objective. It is not because it is not equipped to understand. I'm sure that every judge of the superior judiciary is well equipped to understand that, but they don't have the wherewithal. They don't have the support system. When I enunciate a policy, say in the telecom sector or in the IT sector or any policy in the government of India, whether it's the land acquisition bill that we are hoping it will be passed in Parliament, or the food security bill, it doesn't happen overnight. In fact, the process of actually formulating a policy takes much more than, it takes much more than 1 year. There is discussion with experts, there is the bureaucracy's past experience, there is the nation's past experience, there is the issue of resources, there is the issue of what kind of subsidies ought to be given, there is the issue of what kind of incentives should be given, there is the issue of the health of the corporate sector, there is the issue of the status of the industry as it stands today. If it's a nascent, new, virgin territory, then you need to have a different kind of approach. And then there is, through this collaborative effort and this dialogue, you ultimately end up enunciating a policy. Now, that support system is not available with the judiciary. So if the judiciary was to actually decide for us as to how to go about and what policy there should be and how that public interest is to be achieved, then there will be problems. If we were to decide for government as to how they should manage their growth, there will be problems. What we need to do is distance ourselves from the nitty-gritty of business. Allow corporate procedures to evolve. Allow them free play in the joints. Make sure that we do not interfere in their day-to-day processes. Give them a policy framework. Make sure that your guidelines are clear. That they are not vague. That they are not subject to the kind of interpretation which will allow individual officers to give their own interpretation to the guideline or to the rule. As long as there is clarity in the policy framework, the business community would be happy to move forward. But if there is lack of clarity, then naturally you will subject the business community to all kinds of litigation. Therefore, your taxation systems must be simple. We must make sure that everybody knows what tax he is to pay. Everybody should clearly know, especially the manufacturing sector, as to what item is subject to excise and what item is not subject to excise. Everybody in customs must know that this particular item which is to be imported has this amount of duty. Once you bring clarity into the system, and that will only happen if the policy prescription is clear, then there is no problem. But policy prescriptions are not clear. And many a time policy prescriptions don't have the kind of objectivity that I talked about when I started making my intervention. Because sometimes policy prescriptions are framed to favor A or B. That's when problems arise. As long as you distance yourself from an individual problem, and look at the larger interest of society, you will never have a problem. Why did you give a 5%? Why did you have this item on 5% duty? Why did you give an exemption here? Once those issues are not clear, and it's the Chancellor's foot that decides, the problem arises. And we see the imprint of the Chancellor's foot everywhere. The corporate sector also suffers from the same competitiveness that I talked about. Within the corporate sector, there is no unity of purpose. Someone has CDMA technology, he pushes the government in a particular direction. The other has GSM technology, they push the government in another sector, in another direction. Then they'll fuel litigation against each other. They will give public statements against each other. Because, again, there is lack of objectivity. Because the vision is one. The vision is we need a strong, robust economy that serves the Aam Aadmi, that makes his life better. But if we want a strong, robust sector, there must be unity of purpose. Now that's on the larger. This is on the concept. I wanted to place this conceptual framework before you, because unless we as a nation are clear about concepts, we'll not be able to move forward. Now where does the problem lie today? Take the judicial system and take the business community. I want to know, in the last more than 60 years, have all the chambers of commerce come together and said to us that, look, in the steel sector, these are these experts that we have, who have enormous knowledge about the steel industry. In the shipping industry, we have these experts who have enormous knowledge of the shipping industry. In the telecom sector, we have these experts. Have any chambers of commerce come to us and said, this is a panel of experts that we have, and if there is any dispute that arises within the system, these are our people who will resolve these disputes dispassionately. And so when you have an arbitration panel, please choose out of these people. No attempt in the last 60 years. I ask why. We have today an arbitration system where we require a judge of the High Court to decide complex issues about the steel industry, or a retired judge of the High Court to decide complex issues about marine engineering, about lay time. Why? Why hasn't the industry come forward with solutions? Why should we have an arbitration act which refers everything to retired judges of the High Court who make merry after retirement and who understand, I'm sorry to say, very little? They have great knowledge of judicial principles, but understand very little of the nuances of business. Why can't we travel where we can serve the larger interest? We can easily amend our arbitration laws and make sure. And industry should tell us that, look, any litigant before these arbitration panels should be given enough time to prepare for the case, namely 6 months, 3 months, 4 months, whatever. But after the case is fixed, there shall be no adjournment. Government would be very happy to enforce that. But industry is not coming forward with it. India should be the center of arbitration in this part of the world. India is an emerging economy. China has emerged. The largest portion of global trade will happen in this part of the world. India has a great opportunity to be the center of arbitration for global trade. But we've not been able to do it. Why? Because we don't have a vision. We don't have the necessary objectivity to decide for ourselves as to what is good for our industry. And the industry is not playing a constructive role in this. And once there are experts to decide these issues, there is no problem. I don't think any court can interfere. The arbitration system today perhaps is as it functions today, is the worst form of alternative dispute resolution. Why can't our political establishment as well as the judiciary come together and say that in an era where India is seeing enormous foreign direct investment in this country, where foreign investors have a deep interest in taking advantage of the depth of the market here, that we will set up separate commercial courts which will only hear those matters on a day-to-day basis. The judiciary and the government can come together on this. Remember, the fact that they are the judiciary doesn't mean that we are at odds with them. In fact, there should be a larger dialogue with the judiciary on issues of national importance. The fact that we should set commercial courts is not interfering in the judicial process. Why can't we have a joint conference with the judiciary